I will ask my next question to Attorney Karim Daher. بغنى عن التعريف بس رح أعرف عنك. You are an international business lawyer and tax advisor and a lecturer at St. Joseph University. You've represented the Beirut Bar Association at the Parliament for the drafting and adoption of several financial laws. You chaired the BBA's Committee for the Right of the Depositors, and you are an advisory member of the Anti-Money Laundering and Combating the Financing of Terrorism Compliance Committee. Building on what we've already heard from Mr. Loai and from Federico, and knowing that increasing the revenue mobilization is one of the core objectives of the current government and of the budget, the draft budget 2026. From your perspective, from the private sector and as a tax expert, how do you assess the measures that are in the budget proposed in the budget 2026? Are there things that should have been addressed and that we still don't find in the proposed tax to increase revenue and to broaden the tax base, moving towards really sustainable tax reforms?
Actually, I cannot ignore the attempt that has been made by the government and the goodwill concerning the budget 2026 and has been implemented as measures, courageous measures also, for the first time. But still, I may consider that it is below the expectation, and we are very far from the objectives that has been set by the government at the beginning of the mandate, when they have said, you will judge us on the budget 2026. And it's not critic as much as it is kind of recommendations of some measures that still can be included by the MPs, our friends, in the budget law 2026. I have actually two main remarks or comments on the budget 2026. The first one is that this budget sets a substantially increased revenue projection based on a commitment to increase tax compliance and without resorting to new or increased taxes. Indeed, it's true. But isn't it too optimistic? And is it based on economic impact assessment? Did the government study the implications of those measures? And if ever the revenues that are expected, and we have an increase of practically 75% in comparison with 2024, is it realistic that we are going to perceive those revenues? This is my first remark. Within this first remark, let me say that it is based on two main items. The first one is the increase of the revenues at the customs, because there are scans are expected to be put at the borders. And the second one, and here I have a critic, concerning the advance, what the government called, or the Minister of Finance, the advance tax of 3%, which actually is a withholding tax that is requested from three key players. The first one is the state or the public actor that may add 3% on all the invoices and bills. But if we read the provisions of the article, it applies only on those who are registered at the Ministry of Finance and at the VAT. Which means that we are pursuing those who are actually paying their taxes and they are registered. And we are adding 3% without any explanation concerning the modality of implementation of this tax, if ever it will be retrieved by the taxpayer, how, when, if ever the state doesn't pay this tax or reimburse this tax, what are the penalties, the interest that will be paid, but more. Now I am at ease because I know that my friend, the director, Mr. Hadi, is here, but in 1 year he will not be here anymore. What will be done as a discretion or arbitrary measure by the Ministry of Finance if they don't have the money to pay back the companies or the taxpayer that are actually that they have not generated revenues or they have benefits, net profits, and I want to retrieve this amount. And if ever they are going to tell them, okay, we do not, they will not going to tell them, but they will act. They will try to make an application of a tax assignment and tell them, no, we will study your accounts, and at this moment go and proceed to the opposition and objection near the Ministry of Finance, and thereafter near the state, the Council of the State Council. This is what is very dangerous in this kind of measure. Apart that, this is what we call cavalier budgétaire, because such a measure should be studied and took out of the budget because it has no place in the budget, and with full details implemented by a special and independent law. And I think that the Constitutional Council, if ever there is any attempt near the Constitutional Council will decide to cancel or delete this provision because there are precedent. The first precedent is that it is not clear enough, and we have precedent, and the second one because it is a cavalier budgétaire. The second remark concerning the budget 2026 is that we have, like the precedent budget, they breach the Constitution with the Article 87. We do not have a settlement law, as you witness. We do not have a settlement law. Plus, there is a breach of the core principle, the budgetary principles of the unity and universality, because, and Mr. Lima has addressed this in his speech, we do not include all the expended public expenditures. Let us take as an example two of them: the fuel, the Iraqi fuel, because the state is guaranteeing the oil, and two, we have also the interest on the Eurobonds that are recorded and we are considered till now as due by the Lebanese state. The third remark is that this budget, like the other also, relies overwhelmingly on regressive indirect taxes. The tax burden continues to fall disproportionately on lower income households and compliant taxpayers. This is a problem that still exists in all our budgets. Is it a reason to say, or an argument to say, or the argument that is used by the Minister of Finance or the Council of Ministers to say, okay, those are the sole measures that we have. Nothing can be done at this stage to address inequities, but I am not convinced by those arguments. I will tell you why. Because there are some measures, immediate measures on the short term to increase the revenues, and we have also measures, some of them has been mentioned by Mr. Loaish Hadi and by Mr. Lima, and other, I will mention some of them as an idea of what can be done on the short term, on the medium term. First, on the short and immediate term, the state, the Lebanese state, may recover dues from carry operators. Why not to retrieve or to proceed to collect those amounts that are due? If ever they tell us, yes, it will take time, I will say no. And my friend Mr. Loaish Hadi knows that we have all the tools in order to pursue those persons. First, we know that the Lebanese government has a general pledge. If ever those persons do not pay the dues, the state, the Lebanese state, make seizure of those carriers. Second, if they do not pay within a time frame that is defined by the law and the the Code of Tax Procedures, it is tax evasion. It is defined in the code. And if ever it is a tax evasion, and though the money has been reinvested in real estate or sent abroad, this is a money laundering with a jail between 3 and 7 years, and they have to pay twice the amount that is due as penalty. And this will come to the treasury. This is a very important measure that can be adopted immediately because they have the means and they have the tools. Second, the same recover also dues and areas from public properties. We have a law that has been adopted in 2017, the Law 64, in principle for the regularization of those situations. Till now, we are below the expectation, and we are very far from the objective that have been defined at that time. We have also a measure that has been adopted by the Budget Law 2019 concerning the obligation that is made to the municipalities to identify all those who are not registered at the Ministry of Finance in the circumscription. And I understand the municipalities with scarcity. Well, yes, possibilities, but we can provide them with incentives, like what has been made for whistleblowers in the law number 83. We provide an incentive to the municipality that help to collect those amounts, let us say 10%, 5%, 15%, and at this moment, believe me, all will proceed. We have also, and this is a very conflicting subject matter, and I think that all the person on this table will agree with me, concerning the CRS, what we call the CRS, the implementation of the law number 55 that has been adopted in 2016. Lebanese government and the Ministry of Finance is entitled today to request information upon request, and if ever they achieve the action plan that has been agreed with the OECD in 2019, they may receive on yearly basis information on all Lebanese residents, either if they are Lebanese or foreigners but residing in Lebanon, or on their revenues from their movable revenues abroad. This may help also to increase the revenues, and this is very fair, and this is very easy to be implemented. Those are ideas, and I will not duplicate what has been said by Mr. Loash Hadi concerning the implementation also, or the adoption of the decree for the bank secrecy. Those are immediate measures which are not difficult to implement. We have on the midterm, will not take too much time, but I will also back the proposal of the change from the scheduled tax that we have currently, and Mr. Lima has already addressed this issue, and replace it by the general personal income tax on the whole revenues, which means the local and the revenues that are generated abroad, except if those revenue has been generated through a permanent establishment abroad. We should apply the international standard. We cannot adopt tailor-made standard in Lebanon because we do not want to attempt to the privilege of some person, of some organizations. We should adopt the international standard. Two, we resort to the new technology, and I think that His Excellency is here and he's doing a great job with his colleague, our friend Dr. Kamal Shhadi. We may implement algorithms, data mining, we may implement the e-government, the blockchain system, link all the administration and the ministry between themselves. This will help to highlight the flows and to pursue the recalcitrant. We may also introduce, and you will speak about it, Mark, we also may introduce earmark taxes. Mr. Lima has addressed one of the earmark taxes, which is the sin tax. But we have also other ideas concerning the sin taxes. I will give you some ideas about it. We may apply on natural resources or on monopolies, also increase the taxes on monopolies. We may also apply, and I think that we have two MP friends that are here and they may agree with me concerning the earmark taxes on profit that has been made during the crisis, concerning SIRAFA, which is already existing, concerning the subsidies, concerning the repayment of loans at less than their value. And finally, we can pursue the recalcitrant also with severe and with deterrent effect of the sanctions, and especially the enablers, like me as a lawyer, or an auditor, who are enablers and facilitate the unlawful optimization, tax optimization. Let me stop here because I have several other ideas, but I think that I will not have any friend anymore in this, in this room.